Let's focus on our local airline industry now. The records relating to the sale of SAA to the Takatso Consortium will not be made public. The Western Cape High Court has dismissed an urgent application by Toto Investment Holdings with costs. Now, Toto was one of the companies bidding for the national carrier. Although certain documents will remain confidential to the public, it must still be made available to the court, which is a win for the investment company. eNCA's Monique Mortlock reports.
The application is dismissed with costs, which costs to include the costs of two counsel were so employed.
Toto Investment Holdings was unsuccessful in its urgent application to the Western Cape High Court. The court ruled against its application to stop the sale of 51% of SAA's shares to Takatso Consortium. But there is one silver lining for Toto.
When dispatching the record in terms of Rule 53 of the Uniform Rules of Court, the first and second respondents shall dispatch both 2.1, a non-confidential version of the record, brackets the non-confidential record, and 2.2, a confidential version of the record, in brackets the confidential record. 3, the first and second respondents shall dispatch the record as contemplated in paragraph 2 within 20 days of the date of this order.
Only the litigants will have access to the confidential documents related to the SAA sale, bound by a confidentiality agreement. Judge Nathan Erasmus found there was no urgency in this application, which Toto brought in August.
The applicants knew what the situation was in June when they launched the main application. They chose not to apply for interim relief, and nothing has changed between then and now for them to approach the court on the extreme urgent basis as they did.
This is just one leg of the legal battle between Toto and government. In January next year, the courts will hear the company's main application, the review and setting aside of the sale. Monique Mortlock, Cape Town.